See Mr. Sessoms. Ah, there you are. Hello, Ms. Hamill. Okay. FHY versus, all right. You're up, Mr. Sessoms.
Thank you. Let me start my stopwatch here. I'd like to reserve 3 minutes if I could.
Will do.
This is a paternity case. As you likely recognize, the child at this point is 10 years old. The original paternity action was filed in 2015 when the child was 5, and by admission of both parties, the child had lived exclusively with the mother, who is my client and the appellant, for the first 5 years of the child's life. That litigation resulted in a 2016 final judgment of paternity, and essentially the father received every other weekend time sharing with Wednesdays on a non-overnight basis after school. At the time of the final judgment, importantly, the father lived in Odessa, Florida, which was about 48.8 miles direct line as the crow flies to where the child lived, primarily with her mother in Brandon. Almost 2 years later, the father filed a supplemental petition to modify and sought equal time sharing. The child had begun counseling with Dr. Andrea Thatcher when the child was almost 6 years old. So the child at the point of trial in this paternity litigation modification action had a 4-year-old relationship with Dr. Thatcher. Prior to the trial, there was an emergency hearing. The parents had an altercation between the two of them. There's video of that in the record, which shows a very highly acrimonious circumstance on both sides. There was an emergency motion that the mother filed.
Mr. Sessoms,
Yes.
Before you go to that hearing, if you could clear up something for me, because you had said that Dr. Thatcher was the therapist here prior to this one hearing that you're going to go into. Dr. Thatcher, I think in 2018, there was a hearing. Can you tell me whether or not Dr. Thatcher previously raised the privilege issue at that point in time?
Dr. Thatcher never raised the privilege issue until, let me back up just for a second. When Dr. Thatcher was served just a couple days before the trial, we had tried to work it out. She had some medical issues with the child. We couldn't work it out. We subpoenaed her several days before the trial, but the trial was disjointed. There were a day in early October and a day later in October. And she showed up the first day of trial with counsel, didn't raise privilege, had not raised privilege before that first day of trial.
But she had testified in proceedings before the trial court and involving discussions between her and the child. Is that right?
That's correct. And in deposition testimony, extensively. She was deposed by both parties before the emergency hearing, was what my reference to the emergency hearing. There was an emergency hearing. She was deposed, and she was a witness of that hearing. Never raised privilege. Never raised privilege when she was subpoenaed. Never raised privilege when she appeared the first day of trial and said, "I have a medical issue," and we agreed she could show up later on. I think it was October 27th was the actual day of trial, and then raised privilege a couple days before the trial. We briefed it and wrote our memorandum, showed why the case law is that if you reveal privilege, that you can't.
But the privilege issue. But isn't the privilege issue really this is a matter for the child to hold? And if the child can't speak, then it's for a matter for a guardian ad litem. And I recognize your cases on the issue of waiver and that it cannot be reinstated. But if the child holds the privilege, then if we find no waiver, then the trial court, jumping to your second issue, rightfully didn't allow the deposition testimony of Dr. Thatcher.
I disagree. 90.5033D says very specifically that the therapist has the authority to claim the privilege. And segue into another argument. If the therapist is not an expert and it is not a therapist, that privilege doesn't even apply. And remember, the court said there's no establishment that this person is an expert.
But your argument was actually opposite of that, which was that the therapist was an expert and that you had met those requirements. Is that right?
Correct. I'm showing.
I understand.
Logical. So then go to the issue of the guardian ad litem. A guardian ad litem can be appointed, and that's the Hughes versus Schwartzberg case 872 Southern 2nd 996. However, this court in Barron versus Barron, in a 2006 decision, ruled that a trial court was not required to appoint a guardian to assert or waive the privilege. But 90.503D says that the privilege resides in the therapist. And remember, the father was at the deposition. The father was at the first hearing, never made any arguments about this. We believe that the therapist somehow was, told if you testify and waive this, there may be an issue, but that's not a record. We don't know. But we do know that it was clearly waived and that there is no law to suggest other than what we're arguing, which is the established precedent is when you have the right to assert a privilege, which the therapist did by the evidence code, and you don't assert it, it's waived. And once waived, it cannot be re-invoked. That's the HJM case versus BRC. It's been applied to therapists in the Sajun, SAJIUN case versus Hernandez and HJM versus BRC. There really is no dispute unless the court somehow makes new law on a point that's contrary to the statute on evidence to provide that the therapist couldn't assert the privilege. If I've answered the court's question, I'll move back to the issues that I was stating. So, established relationship with Dr. Thatcher. Dr. Thatcher showed up at the emergency hearing. Dr. Thatcher said in her deposition, which we've referenced in the record, that the child was fearful and had anxiety towards the father. That's in the record unrebutted at 738 to 935 is her testimony, which was sealed, which we'll get to in a minute, and we ultimately were able to unseal it. And she says very specifically in that transcript, one of the first things she tries to do is to tell the court her concerns, and that's on page 7 of the actual transcript, where she's trying to elucidate to the court the child's concerns, and the court cuts her off and wants to talk about this particular videotape. And remember, there's a videotape of an altercation between the parties, which clearly is on both sides. My client contended she was physically assaulted and injured her knee in the process. The father said the mother wouldn't
Doesn't the
leave.
child's referring to the transcript that you were just talking about, where the Dr. Thatcher talks about the anxiety of the child, doesn't that really relate to the I think it was something that the child had mentioned to the therapist, that she was upset because the father wasn't paying for the child's gymnastics. And then, of course, that gets into the fact whether or not the mother's alienating the child, and how is the child supposed to know about all these types of more parent issues.
The only testimony about the cause of the anxiety is from Dr. Thatcher, who said very specifically that the father has anxiety and is afraid of the father. There is testimony in the quote unquote interview, which we contend was not an interview at all. It was just the trial court telling the expert what her opinion was and not listening to the expert. There is a reference, as you suggest, to the issue of gymnastics and the payment, but there's no connection between that and any problems with the child. Remember, the father testified very clearly, as did the mother, this child's doing fine. There is no record evidence from the father in any way, shape, or form that there's any detriment to the child at all from the current situation. And we know from the case law is that for there to be some change in time sharing from a res judicata effect, there must be an extraordinary showing. The case law is replete in that respect. There was not in this regard at all. The father testified that there were 4 circumstances that he found. I acknowledge he pled for more, but there's 4 issues that he raised that he thought would be justifiable in terms of a change of circumstances. He asserted relocation. Relocation in and of itself is not sufficient. There's many, many cases that say that. The father points out in his reply brief, hey, wait a minute, all these cases relate to the issue of the child or the parent moving farther away. There's none that relates to a parent coming closer. But there is now a case that we've cited in our reply brief. After they filed their answer brief, we filed the reply brief, and we cite to the case of Bryan versus Wheels, 2020 Westlaw 209-1531, which is a May case. And in that case, the parent moved from New Jersey to Florida, and the first DCA found that to be inadequate in terms of a basis for a change in circumstances. Hostility or animus, again, the case law is replete that that's insufficient alone to justify a modification.
But if we look at these cumulatively, could we not find? I mean, I recognize that relocation in and of itself is not going to be a substantial change in circumstance. But if we look at the circumstances that the father is complaining about, and we look at them and, together, would they not meet the standard of substantial change in circumstance here?
I contend no, and that's why I'm breaking them down individually. He testified to 4, and none of them either separately or I would contend cumulatively, because separately they're not sufficient, and in the aggregate they're not sufficient because none of them by established law is sufficient. The issue of hostility or animus, they cite 2 cases where there's medical consequences to the child. There isn't here. We have a child who's doing fine. There's no predicate. When you have testimony by the litigant who's seeking a modification that this child is doing fine, I would contend that the established case law, without something else, is insufficient. He's trying to create inferences by things that were discussed with the therapist under seal. So we didn't even get the chance to deal with the issues that Dr. Thatcher attempted to elucidate, or the court's very strident remarks before we even had the opportunity to present our case to the expert or to the court. When you look at the cumulative effect of how the court handled this case, I would contend that there is no question that there was fundamental error, that there was bias in favor of a rotating time-sharing arrangement, and the court simply arranged the bricks to fashion a wall in the circumstance of 50-50 time-sharing. And we think that the established case law is that where a trial judge's actions deprive a party of a fair and impartial tribunal, reversal for a hearing before a different judge is appropriate. Reading that sealed transcript, which we had to unseal and had get a court order to unseal and look at.
But wasn't, Mr. Sessoms, but wasn't the remedy there to seek a petition for writ of prohibition after the hearing? If you're claiming that the bias at that time, if it was apparent during the hearing, wouldn't it have been timely then to file it immediately following the hearing?
It could have been, but there's also case law that says that you can raise it on appeal as a matter of fundamental error. We didn't have the sealed testimony. When we unsealed it, it all became apparent what was happening. And the court goes on and on from right out of the gate. She says on page 5, she launches in about the video and says, "Have you seen this video?" And the expert says, I haven't seen the video. And then the court continues to berate her. She tries to tell the court in response to the question about her impressions of the child's relationship with the father, and the court shuts her down. All the court wants to talk about is the video and the effect that video had on the court. And all the video is of the mother refusing to get out of the vehicle when the father won't engage in the discussion about the effect of the child going to a very loud USF football game, and the mother's contention that loud stimulus caused problems for the child. Some children have problems with loud noises, and that was her contention. But for the court to take that and somehow leap from that to a justification for a modification, there's no case law that supports that. And at every turn in the testimony, when you go back and look at the testimony, the court would bend over backwards to help the father. And the court would chastise and basically said to my client at the end, you're sick. Well, it's all based on a video, which clearly she can make determinations as to what she thinks it sees, but objectively, it doesn't justify any standard for a modification under the existing law. We also attempted to subpoena the ex-wife of the father, and we obtained drop service over the over the former wife, and she turned and walked inside, and that's when the process server dropped. We have the return of service. We moved to hold her in contempt, and one of the sanctions would have been to have her come testify, and the court declined. The court wouldn't let us use the court determined for whatever reason that because we couldn't show a CV of Dr. Thatcher, she wasn't an expert. Again, I think I've already detailed the reasons why she clearly was. We'd all recognized her an expert. There's case law that says when litigants have recognized someone as an expert, that's sufficient in a deposition. I've cited that case. She goes into great detail about her notes and her therapy of the child in that deposition transcript. And so even if we couldn't show her CV, we could show that based on her training and experience, she was functioning as someone who was an expert. And we attempted to use that deposition. There's no basis to prevent us from using an expert's deposition, which can be used under the evidence code at any time for any purpose. The experts' transcripts are used. All that's prejudicial because now we don't have in the record, other than our argument, that Dr. Thatcher was the one who opined, contrary to what you're suggesting, Your Honor, that somehow this child was negatively affected. The only negative effect on the child was the anxiety that was caused in the child's relationship with the father. Now she didn't expound on it other than what she did in her deposition, so we don't have the full panoply of what we contend Dr. Thatcher would have said, but we do know that we have her basic opinion there. With that basic opinion that's unrebutted, I don't see how the court could be permitted to draw the inference that somehow the mother's, as you suggested, alienation over this gymnastics payment would be sufficient to allow the court to make that decision of modification. We've also filed a motion for attorney's fees and costs, and we would ask the court to pass judgment on that under Rados, and we believe the trial court can determine, hopefully a different trial judge can determine how the fees would be allocated. And with that, I'll save the balance of my time for rebuttal.
Thank you, Mr. Sessoms. You have right at 3 minutes. Ms. Hamill, excuse me, Ms. Hamill.
Good morning. May it please the court, Kim Hamill of Older, Lundy, Alvarez, and Koch on behalf of the appellee, who's the father in this matter. I will start with the issues surrounding Dr. Thatcher's testimony. And while Dr. Thatcher has certainly the ability to assert the psychotherapist patient privilege, the mother is asking this court to say that just because the psychotherapist has the ability to assert the privilege, that they therefore also have a unilateral and unwaiving ability to waive the privilege. And that's not set forth in the statute. And 90.5.
Ms. Hamill, back to my question that I had before. It appears that this wasn't the first time that Dr. Thatcher was familiar with the trial court, although not this judge. But didn't Dr. Thatcher previously testify at another hearing the year prior? That privilege was never raised at that point in time?
It's my understanding. I don't believe that there's any anything in the record regarding the actual testimony.
There's not. There's an order that talks about Dr. Thatcher in the testimony, and so I have to wonder if the privilege wasn't waived then. If the privilege wasn't raised then, how it's being raised at this point in time.
I understand, Your Honor. I think the issue there is, while she has the ability to assert it, and certainly having multiple individuals under 90.503 have other than the privilege holder, have the ability to assert the privilege only adds further protection. But when you're talking about waiver, having multiple individuals other than the privilege holder have the ability to waive, that certainly doesn't add more protection. In fact, that causes concern. And
well, I
isn't
guess
it also
so.
true,
Oh,
isn't it also true, Ms. Hamill, that a waiver, a privilege applies to a communication? So the waiver of the privilege as to one communication does not waive the privilege as to another communication. Isn't that correct?
Yes, I would agree with that.
The fact that she did not assert a privilege previously only has bearing on this issue to the extent that she did not assert a waiver to a communication that is relevant here. And we don't know what that was, correct?
Yeah, yes, Your Honor. And I think that on that point, one, we don't have the testimony or to confirm that she did in fact testify at that emergency hearing. We only have a deposition transcript. And in talking to the the Bolin v. State case, that case is, although it involves a spousal privilege and it's a criminal case, it's comparable to the issues that we have before the court today, because in that case, the Mr. Bolin, his counsel, took the deposition of the individual, of the spouse. And we have a similar circumstance here where the deposition of Dr. Thatcher was taken for discovery purposes. And that was because the mother in her emergency motion cited to Dr. Thatcher's recommendation that Dr. Thatcher had with regard to time sharing. So diligently, trial counsel took Dr. Thatcher's deposition to discover those facts, but that doesn't mean that is a waiver of the privilege as the mother has asserted. And I think the Bolin case speaks to that, that such a discovery deposition does not constitute a waiver. And that's the argument.
Ms. Hamilton, so what's to prevent someone from a bad deposition testimony then later on asserting the privilege, right? Using it as a sword later, not raising at the opportune time when they should have, when they had counsel, right? Everybody had counsel at the time. So what's to prevent that?
I agree that that's certainly an issue. And I think in this case, it's unique because the mother asserted claims in her emergency motion, and obviously in family law, emergency motions can be handled sort of expedited and somewhat due process is certainly applicable, but we also have to think about the best interests of the children. So we need to act on those very quickly if needed. So the deposition was taken because the emergency handling order said, Judge Polo said, the therapist must be at this hearing. Somewhat problematic. What do you do in that situation when you're counsel for a litigant?
Raise a motion for a protective order, raise the privilege, right? So let me move on from this because I think I understand both of the arguments. I'm troubled by what happened in camera between the trial judge and Thatcher. So, and I realize this is one of the last arguments that are raised here by the mother, but it's troubling to see the questions and the way that they were asked. And really, there's a lot more of the trial court testifying than there is the doctor. There's a lot of really not much substantively by Dr. Thatcher. So that is troubling to us. So what is your response in that regard as to why we shouldn't send this back for a new trial before a new judge?
Well, I would agree that the transcript of that interview is hard to read because of the back and forth between Judge Pomponio and Dr. Thatcher. I do believe that there was substantive information provided by Dr. Thatcher, but Judge Pomponio also appeared from the very beginning. I believe Dr. Thatcher said something along the lines of that she wasn't really aware of the present circumstances. I think the record reflects that she was on maternity leave and hadn't treated or seen the child for a few months, wasn't aware of the circumstances regarding.
But the circumstances are as relayed by the trial judge. It's not that, and the trial judge describes what happens on the video before the video is even shown, right?
Yes, I would agree with that summary of the facts in the record. But I think the issue here is that Judge Pomponio realized that Dr. Thatcher didn't have a lot of information relating to the current best interest of this child, didn't have any information between the therapy between the father and the child, which was a separate therapist, and didn't have any information regarding the child as we sat at that.
But the information from the father had to do with the father not getting back with Dr. Thatcher, which is what Dr. Thatcher was trying to tell the judge at that time, correct?
I'm not certain I understand.
The information, I guess the lack of information that Dr. Thatcher had with respect to the father was the fact that the father, even though Dr. Thatcher had said, hey, we need to have you with the child, the father never got back with Dr. Thatcher about that for whatever reason.
Right. And I think if you read the record in its totality, the issue here was that the mother selected Dr. Thatcher as a separate therapist, which was not the court ordered a therapist for the child. And there was a lot of acrimony between these two parties. I think that's very apparent in the record.
No doubt.
And so I think that the issue with the father was, I have a therapist that I see with my daughter. Mom has unilaterally decided that the daughter needs to now be involved with Dr. Thatcher. Do I really need to be involved with Dr. Thatcher when I have court-ordered therapy in place? And so I think that's a tough issue for a parent when there's this level of acrimony between the parties.
Well, the issue, though, the question I think it had to do, though, with what Dr. Thatcher's present knowledge was, and if she was asked, who have you seen most? She said, I've seen the mother. Father didn't get back to me, and without ascribing any blame or purpose to anyone for purposes of making a custody or a visitation call. The question is that for whatever reason, how much current knowledge did Dr. Thatcher have from whatever source?
Well, I would agree.
One
And
way to look at it.
I didn't hear that last part. I'm sorry, Your Honor.
I said that's one way to look at it.
Yes, I would agree. And I think that was obviously a concern of Judge Pomponio because she asked Dr. Thatcher. I think that's how this fact was ultimately presented, was because Judge Pomponio asked Dr. Thatcher who she speaks to more, which parent. And because
correct.
she had
But I will say, and as Judge Smith pointed out, that was a pretty combative interview. So it seemed. So because Judge Pomponio said, so basically the mother is spoon feeding you what she wants you to hear, or words to that effect. I mean,
I think it reflects the concerns that Judge Pomponio had already, that the record already reflected with regard to the mother.
This is, and I have this other question then, because as I'm reading the order, I mean, Judge Pomponio referred to the mother's quote, disrespectful, inappropriate behavior toward the court at trial, the stack of talking parent messages that she found inappropriate, where she attributed to the mother and her attempts to interfere with the parties or the father's time sharing, and the Christmas 2016 fiasco. Do you think that there's anything in the Dr. Thatcher's potential testimony that would have altered Judge Pomponio's view of the situation?
Not necessarily. I mean, I think that Judge Pomponio definitely heard the testimony from Dr. Thatcher that Mr. Sessoms was referencing with regard to the anxiety of the child. And the court has the duty to judge the credibility and the facts, especially in a family law proceeding in a bench trial in this circumstance. And the trial court was clear in her findings that the mother has been a significant issue in prohibiting the relationship between the child and the father in this case. So,
Ms. Hamill, and that leads to the more substantive issues as far as whether or not there was a substantial change in circumstance and whether or not this was in the best interest of the child. And so that alone, though, alienation is not something that we can hang our hat on, right? Nor should the trial judge.
Well, the acrimonious relationship between the parties is not something that the court can hang their hat on alone. But there's cases that I cited too, which are, I believe in 2019, 2020 cases, the Schote v. Schote case and the Ezra case, that speak to when that level of acrimony is so heightened. And I believe Mr. Sessoms characterized it as extreme acrimony in the beginning of his argument, is so heightened that it's impacting the child in a family law case, that the court.
Okay, and how was it so in this case, how was it impacting the child? Because I think that's what we need to look at. So let's say we find there's a substantial change. But how is it impacting the child here, where both parents are saying that the child is doing well?
Well, the testimony of Dr. Thatcher, that the mother thinks is so important in this case, said that the child has anxiety.
But let's say we're not going to rely on Dr. Thatcher's testimony, right? Let's say because if we hold that the privilege wasn't waived, then we can't look at Dr. Thatcher's testimony. So without that, what do we look to?
Well, we look to, and I will just point out that the appellant hasn't raised any issue with regard to they're not the best interest factors. They've only raised the issue of there not being a substantial change. But with regard to the best interest factors, the father, I mean, this is a paternity case where the father wasn't involved. The mother prohibited overnights for the first 4 years of this child's relationship, of this child's birth. And the father, of course, was limited in the first final judgment on his time sharing to 4 overnights a month. So now the issue here is not whether relocation on its own can be a substantial change, not whether the acrimonious relationship on its own can be a substantial change. I agree that on their own they cannot. However, here we have a father who has now built a relationship with his daughter over a 2-year period of having only 4 overnights a month, made the effort to move closer to the child's school. And Judge Cook in the initial ruling stated that was a primary consideration in him having non-overnight time or non-school, not having overnights on school nights. So he took that, he moved closer, and it was because of the distance. You'll have to be in the car for 30 minutes in the morning. And so he took it on his own initiative as he continued to grow in his relationship with his daughter to move closer. Then you have the issues of mom continuing to do everything she can to prohibit this relationship, as she clearly did prior to the final judgment. So she's continuing to act in that manner, preventing her from going to her stepsister's or half-sister's graduation, family events, anything that would promote the relationship of this child with the father and with the father's other children and family, she was prohibiting. And I think the evidence in the testimony is very clear on that. So it's the totality of the circumstances with regard to the relocation, the acrimonious relationship having an impact on the child, and the fact that the father has a relationship with this child that he did not have at the time of the final judgment. That's the most significant substantial change that I think is very apparent in the record. The mother went so far as to not refer to the child's father as dad. When she spoke to the child about the father, she called him by his first name. I think that's significant when it comes to the level of alienation, really, that the mother was exhibiting with regard to this child and the father in this case. And Judge Pomponio was aware of that. She made findings on the record of the observations that she was viewing of the mother during the proceeding, of her rolling her eyes. If you read the transcript, the answer brief, there's references there where the mother was very sarcastic to the court. And so the court is the fact finder. She had to ask questions. She had to ask difficult questions, and she had to make a decision regarding these parties. And I think that it was a tough one, but if you look at the evidence, there's competent, substantial evidence to support the substantial change, as I summarized, as well as the best interest, that this is in the best interest of the minor child.
And just to clarify, Judge Pomponio did not say there was a parental alienation per se. If I understood her order correctly, she said the mothers need to control the situation and extended to controlling the relationship basically between the father and the child. I mean, and in her order, she went through the best interest factors set forth in 61.13, correct?
Yes. Yes, and I would agree that there wasn't a specific finding as to alienation.
Alienation.
The
Right.
actions and the behaviors of the mother and her clear opinion that this relationship should not grow and the father should not have any further time sharing. She wasn't even allowing the court order time sharing at that point in time.
Right.
And I think that's also evident in the fact that she speaks to the stepsister's relationship, that the stepsister would be a victim of this, I believe, of this litigation. She used the word victim. If the father would have would really take away time sharing between the stepsister and the child of this in this proceeding. But the mother also didn't allow really important events for the daughter's half-sisters. So it was sort of what she wanted, but not what the father wanted. And I think the evidence clearly supports that. I wanted to also just point out briefly on the privilege issue, because there was some reference to the language of 90.507 in the reply brief.
And you're down to about a minute and a half, Ms. Hamill, so yeah.
Thank you. I was just about to ask. It specifically says that a person who has a privilege against the disclosure of a confidential matter or communication waives the privilege if the person voluntarily discloses it. And that's what we're looking at here, is a potential voluntary disclosure. And if another person, if it's outside of your hands, if another person can waive that privilege, how can that be your voluntary disclosure if a psychotherapist, for example, can waive your own privilege? So I think that's an important consideration for the court. And I would just also refer to the attorney ad litem for DK and the SCV guardian ad litem cases that really speak to the importance of protecting a minor child's privilege. And in this circumstance, given the unique situation with the emergency motion, I believe that protecting that privilege at the point of the trial, because that deposition and that testimony was not taken for purposes of this supplemental petition, should be considered highly by this court. And so for the reasons stated, I would ask the court to affirm the final order on appeal. Thank you.
Thank you, Ms. Hamill. Mr. Sessoms, 3 minutes.
May it please the court. I think what is missing in terms of the reply is that the first 5 years of this child's life, the father wasn't involved really at all. And then we have a video that shows that the first video that we have shows a very violent interaction between the mother and the father. So to the degree that counsel's arguing that mother wasn't flexible with dad, recall that she contends that the father pushed her down and injured her knee, and that she has an orthopedic injury from that he went on and on in front of the stepfather about that he had killed his wife somehow, just horrible things in that particular video. And the court said that both parents were at fault and made them both write a thank you letter. But remember, this is not just a one-way street. This is two parents not getting along. And the case law is that that's not a basis for a modification. In terms of waiver, the case they rely on, Boland, isn't even a psychotherapist case. And they say, well, there's no way that the child can be said to have waived the privilege through the therapist. However, the child has never claimed the privilege. The vehicle to do that would be through a guardian ad litem, which no one asked for. So all we have is a therapist who waived the privilege several times and then shows up and claims a privilege that somehow they're arguing that that claim is permitted. There's no case law to that effect. In fact, there's the HJM and the Hamilton versus Hamilton Steel case that says the opposite. So there's absolutely no statutory or case law predicate that they're using to make that contention or to support that contention, or to the inability of us to use the deposition at trial. I didn't even hear anything in terms of the response from counsel about why we couldn't use the deposition. On page 7 of the quote unquote interview, I should have said this to Judge Smith. Specifically, Dr. Thatcher was asked by the court on line 15 of page 7, what do you think the mom does to help it, meaning the relationship, to facilitate a relationship with the father? Answer, well, my understanding was, for example, when phone calls, when dad was trying to reach out and call her, mom wouldn't discourage those, quote unquote now. She would encourage or try to say to talk to dad, but Sydney was not always wanting to do that. So to the extent that they're claiming alienation, even though in response to the court, they acknowledge there is no alienation predicate in this particular record, Dr. Thatcher said the opposite. Mom was facilitating it. The only issue, and I recognize in Judge Smith's question and acknowledged it, there was the issue about the child knowing about gymnastics. Kind of difficult when a child can't go to gymnastics because of money to try to lay that out while walking that line, but I recognize the court found fault with that, and that's the court's prerogative. But the issue of alienation is expressly discounted by Dr. Thatcher's testimony, and we weren't able to elucidate on that.
Okay, you're at your 3 minutes, Mr. Sessom, so you need to wrap up.
Dr. Thatcher was out, quote unquote, a little bit in response to you, Judge Northcutt, but she never defined what that was. Sarcasm, there's no ability to really read that on a record, so I would take issue with some of the claims. And the dad versus Paul, remember, the child had no relationship with the dad for 5 years, and Dr. Thatcher said specifically why that was in her deposition, that the name Paul was used by the child, not by the mother. Thank you very much for listening.
Thank you. Thank you both very much. In order to leave, you need to press click the button in the lower right-hand corner of your Zoom screen. And if you click the word